and Mr. Long, I have a plea agreement in front of me. Is that how you want to proceed today?
Yes, Your Honor.
Okay. And you told me last time you were gonna hire your own attorney. Have you changed your mind about that?
Yes, Your Honor.
Okay. As best you can you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can put your hand down. Mr. Long, a guilty plea hearing is important. You waive constitutional rights that you have, so listen carefully. If you have a question, ask me. If you need to talk to your lawyer, you just say so. Now, I have to advise you the maximum penalty that you could face on the charge of false pretenses, over $1,000, but less than $20,000. It's a felony punishable by 5 years and or $10,000 fine or 3 times the value of the property or money involved. Do you understand the maximum penalty?
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor. Non-important probation.
Okay, for misdemeanor or felony?
Misdemeanor.
Okay. And were you on probation for that at the time of this offense in
No,
November
no,
2024? Were you on bond for any other case in 2024 November?
Honestly, I don't know.
Okay. Okay, you're not aware, Mr. Gilbert, of any consecutive sentencing implications
I am
for
not.
other cases? To Mr. Juliet? Or...
I am not.
Okay. All right. And Mr. Long, did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
And you signed that?
Yes, Your Honor.
Do you have any questions for me or Mr. Gilbert about any of those rights?
No, Your Honor.
Do you understand if you plead guilty, you give up those rights and won't have a trial?
Yes, Your Honor.
Is that what you wish to do today?
Yes, sir.
If I accept your plea, you give up any claim that it was caused by threats or by any promises that aren't put on the record today. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you lose the right to appeal. If you wanted to appeal, you'd have to seek permission by filing an application. But the types of issues you could raise on an appeal after pleading guilty are very limited, much more limited than if you went to trial and were convicted. Do you understand that?
Yes, Your Honor.
Plea agreement provides in exchange for your plea of guilty to count 1, the prosecutor is going to dismiss the habitual offender enhancement and dismiss a district court file that I presume that's the absconding
It is.
case. Okay. And restitutions agreed upon in the amount of $6,825. Do you understand that plea agreement?
Yes, Your Honor.
Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
It is, thank you.
Mr. Juliet?
99%, the absconding is now in circuit court, and he's set to be arraigned next week. It's 26/71/35 FH, so I'll just dismiss that.
Okay, so you'll just set up an alley on that then?
Yes.
Okay. All right. All right, Mr. Long, has anybody promised you anything else in exchange for the plea?
No, Your Honor.
Has anybody threatened you to make you plead?
No.
Is it your own free choice to do so?
Yes, sir.
Knowing all this, how do you wish to plead the charge of false pretenses, $1,000 or more, but less than 20,000?
Guilty.
And Mr. Gilbert, would you assist with factual basis?
I'd be happy to. Sir, can you state your name for the record, please?
Tristan Long.
And Tristan, in November 7th of 2024, were you in Sheboygan County?
Yes, sir.
And there was a piece of property in Sheboygan County that an individual wanted to buy from you,
Yes.
and they gave you a deposit for that property,
Yes, sir.
and that was actual real estate,
Yes,
as
sir.
in dirt.
Yes, sir.
Okay, and that dirt was located in Sheboygan County,
Yes, sir.
and you didn't have a legal claim to that property at that time, did you?
No, sir.
And so you did not have the ability to sell that to that individual.
Yes, sir.
Okay, and you know that you can't sell something that you don't own
Yes, sir.
or have any right to.
Yes, sir.
No further questions, Your Honor. Thank you.
Okay, and you satisfied with that factual basis, Mr. Gilbert?
I am, thank you.
Mr. Juliet?
I am.
And Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I am not.
And do you believe I've complied with MCR 6.302?
Believe you have, thank you.
Mr. Juliet, do you agree on both matters?
I do.
All right, Mr. Long, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. We can schedule this for sentencing on let's try for March 10th. At 2:20 in the afternoon. And you'll have to cooperate with a pre-sentence report being prepared. So someone from the Department of Corrections Probation will meet with you to interview you for a report. I guess the absconding being dismissed, we can just dismiss the contempt citation for failing to appear.
That's fair.
Okay, we'll dismiss the contempt citation, but bond will remain canceled. Melissa, do you want to be heard on that question or not?
I was going to ask, Your Honor, I did factor Tristan out. He factors fairly low. We do understand that there was the absconding issue. However, I do believe that somebody being Tristan got scared and made a stupid mistake. As I went through this file, as the court knows, he was going to retain counsel. I sort of inherited the file. Going through it, a lot of it didn't make a lot of sense of why he wouldn't show up. And in talking with him, he completely acknowledged that it was just a sheer fear that he got scared, didn't know what the future held. I really think it probably held fines and costs and maybe some probation at that. Again, when I factor him out, he factors low. I do not think that he's going to repeat that activity and not show up, especially when he knows that pursuant to the plea and how we arrange things, he did very well by getting the absconding removed. And so I don't think he's going to put that in jeopardy. I would highly believe that there's not going to be any issue with him showing back up. Thank you.
Okay, Mr. Long, you still live in Boyne City?
No, I live in Wolverine.
Okay. And does Mr. Gilbert have that address? I don't want you to say it right now on the internet here, but so you have that address, or you can make sure he has it?
Yeah, I will make sure. I'm not sure if he has it, but I did tell the jail.
Okay,
That
so
is-
jail has your current
Yes.
Wolverine address. Mr. Juliet, any thoughts on that?
I know the absconding file is being dismissed, but there's been other failure to appears in different cases. Since it's not too far out, regardless of any jail, I think even though he's in an intermediate sanction cell, bond violations are reasonable grounds to overcome that, failures to appear. So I'd ask that it continue to be revoked.
All right, well. I think I'm not exactly sure, you know, what the sentence is going to be. There's a habitual notice being dismissed, but it was only habitual second. It's not a high public safety concern issue or a addiction compulsion issue here. I think what I'll do is I'll set a bond of $10,000 cash or surety. With were there conditions on the bond previously? Do you know, or I guess I'll just say the same conditions as previously assessed. I don't know whether whether somebody will post for you or not, whether a bond's going to post for you or not, because they lost the bond last time they posted for you, and then they didn't end up having to pay that because you got caught fast enough. But you'll have to talk somebody into posting it for you. If you do post, it's on you to make sure you set up an interview with the probation department for that pre-sentence interview and show up for court. You don't do either one of those things. On the record, I wanted to review some scheduling options with counsel, and looks like we can schedule this for jury trial February 26th, Thursday, and going into Friday the 27th as needed. And that still is pretty quick turnaround. Can we have witness and exhibit lists within 14 days?
Yes.
Okay. And probably no need for further docket call then?
I believe if we get it resolved, we can work something out with the court, Your Honor.
Okay. All right. So Ms. Self, we're going to set this for trial this month, February 26 and 27 as we need. That'll be the next time we're in court. The jury selection will start sharp at 9 a.m. So be here by 8:30 with your lawyer to be ready to go. And it's very important. I know we cleared up a couple things with the bond issues today, but as I mentioned, it's very, very important that you call every day, that when you're required to test, that you test.
Absolutely, Your Honor.
All right, anything further from the people?
No, Your Honor, thank you.
Anything further from the defense?
Yes, Your Honor. My client has a issue in Ohio on these court appearance on the 17th of this month. We'd just like to ask if her bond can be modified so she could leave and go to Ohio for that one time.
Yeah, do you expect that, what does that mean?
It's a hearing because we had suppressed the motion. So we're just going in to go over it.
That doesn't make any sense.
Um,
Is it a criminal case or a civil case?
It's a criminal case.
Are you the defendant?
Yes,
You have an attorney down there?
yes.
Do you expect that, that hearing is going to result in any jail for you? Or any objection, Ms. Goodrich?
No objection.
Okay. Yeah, I don't have any problem with that. I think probably the best approach to paper it is to have a stipulation of that effect.
I can do that.
That's okay.
Yeah.
But I'd sign it.
17th.
All right, we'll see you then, Ms. Self.
17th. 16th. Okay, I'll be there. Make sure you answer your phone when they call, so we gotta start.
All right, and then that would bring us to the 2 o'clock docket. We're a little ahead of schedule. Do you have anything ready on that time docket yet or no?
Nobody that's here in the gallery, but I have a couple that are in jail. Can run up.
That'd be Mr.
Mr. Berky and Mr. Powell,
Okay,
Mr. West.
okay, yeah. All right, we'll go off the record. Back on the record, and up next on our docket is people Philip Berky, file 25-7126FH. We've got prosecuting attorney Ms. Goodrich in the courtroom, Mr. Gilbert for the defense with Mr. Berky present with them. We're here for an arraignment, and I also have a plea agreement in front of me. And Mr. Gilbert, for purposes of arraignment, does your client waive the reading of the information?
My client waives the reading of the information, and the forensic center is not applicable.
Okay.
He stands here.
All right, and Mr. Berky, would you please, as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Can you put your hand down? Are you Philip Matthew Berky?
Yes, sir.
Mr. Berky, a guilty plea hearing is an important event because it includes you waiving constitutional rights that you have. So I want you to listen very carefully. If you have a question, ask me. I'm happy to answer it. If you need a minute to talk to your lawyer, you just ask. We're happy to give it to you. Do you understand that?
Yes, sir.
All right, now I have to advise you the maximum penalty that you could face for the charge, which you'll be pleading to, and that's count 1, possession of methamphetamine. And that is, will you be filing an amended information then?
Yes, removing
To
the drug
remove the
double.
drug double?
Yes.
And you consent to the later filing?
I do.
Okay, possession of methamphetamine in Michigan is a felony crime. It's punishable by a maximum of 10 years in prison and or a $15,000 fine. Do you understand that maximum penalty, sir?
Yes, sir, I do.
Are you on probation or parole anywhere?
Yes, sir.
And which is it?
Parole.
You're on parole.
Yes, sir.
Okay. Is there a parole hold?
Yes, I believe so. Yes.
Okay. You understand then that this, any sentence that I impose would be mandatory by law, consecutive to any sanction that the Department of Corrections determines with the parole violation.
Yes, sir.
All right, and did you read and understand the rights listed on the advice of rights form?
Yes, sir.
Lists your trial rights.
Yes.
Do you have any questions for me or Mr. Gilbert about any of those rights?
No, sir.
Do you understand if you plead guilty, you won't have a trial and you'll give up all those rights?
Yes, sir.
Is that what you wish to do?
Yes, sir.
If I accept your plea, you give up any claim that it was caused by threats or by promises beyond what's placed on the record today. Do you
Yes, sir.
understand that? Also, when you plead guilty, you lose the right to appeal. If you wanted to appeal, you'd have to seek permission to do so. by filing an application for appeal. But the types of issues that you could raise on an appeal after a plea are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, sir, I do.
All right, the plea agreement provides in exchange for your plea to the possession of methamphetamine, the prosecutor is going to dismiss the drug double, the habitual notice, and the misdemeanor no insurance count 2. And there's a sentence agreement that you be sentenced within a specified guideline range of 5 to 23 months. But also if the guidelines score differently and it's not 5 to 23, both parties wish to have the option to withdraw the plea. Do you understand the terms of that agreement?
Yes, sir, I do.
All right, and so Mr. Gilbert, do I understand that that's not just sentence within a specified range, but if you guys are wrong about your anticipated range, that might have affected the decision, and so that's why that's in there?
Correct. Yes.
Okay. All right, is that a full, fair, and accurate statement of the terms of the agreement?
It is.
Ms. Goodrich?
Yes.
Mr. Berky, that sentence agreement is not binding on me. I didn't sentence you that you're on, what are you on parole for?
Cutting off Patterson. Temporary electronic monitoring.
Okay, but I wasn't I don't recognize you.
No,
I-
I've
okay.
never been.
So I don't know you, I don't know anything about you. So at the through the pre-sentence process, I'll know more about you at the time of sentencing. So if I decide at sentencing, well, gee, I can't live with 5 to 23, I would do something different. Then I'm not bound by this. But if I didn't follow this, you'd be allowed to withdraw your plea because you wouldn't be receiving what you bargained for. Do you understand that?
Yes, sir, I do.
There is an important exception to that. If you engage in some misconduct between now and the time of the sentencing, and sometimes people even do it from the jail, like committing a new crime or violating court orders. If you were to engage in any serious misconduct like that, by your own misconduct, you would forfeit the right to withdraw the plea, even if I didn't follow the sentence agreement. Do you understand that?
Yes, sir, we're not gonna have that problem.
All right. Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No,
Has anybody threatened you to make you do so?
no,
Is it your own free choice to enter that plea?
yes, sir.
Knowing all this, how do you wish to plead to the charge in count 1, possession of methamphetamine?
Guilty, sir.
So back on November 7th of 2025, were you in Sheboygan County?
Yes, sir.
It appears that you might have had some contact with law enforcement.
Yes, sir.
Were you in possession of the controlled substance methamphetamine?
Yes, sir.
Did you know that you were in possession of that substance?
Yes, sir.
And did you have any lawful authority in the state of Michigan to possess it?
No, sir.
Mr. Gilbert, you satisfied with that factual basis?
I am, thank you.
Ms. Goodrich?
Yes.
Mr. Gilbert, are you aware of any other crimes, instruction, inducements?
I am not.
Ms. Goodrich?
No, Your Honor.
Right. And Mr. Gilbert, in your judgment, is the court fully complied with the requirements of MCR 6.302?
I believe the court has, thank you.
Ms. Goodrich?
Yes.
All right, and I've received the amended information, removing the drug double. You consent to its filing?
I do.
You waive its reading?
I would agree.
And it's accepted by the court for filing. Let's try to schedule this for sentencing on March 10th at 2:30 in the afternoon. Mr. Berkey, someone from the Department of Corrections, probation parole will be talking to you to write an updated pre-sentence report for me. So you have to cooperate with that process.
Yes, sir.
You have any questions for me, sir?
No.
Anything
Sure.
further from the defense?
None, thank
From
you.
the people?
There you are.
All right, we'll see you then, Mr. Berkey.
All right, thank you.